Good morning, friends. This video may be little longer than the usual one because in this video I am trying to cover all the important legal developments that have taken place post the decision of Rajiv Bansal in the Supreme Court of India so far as AY 1314 to AY 1718 are concerned. We are aware that so far as AY 1516 is concerned, it is a cakewalk because it has been conceded by learned ASG before the Honorable Supreme Court that the notices deserves to be dropped, as the cutoff date do not fall for completion during the period specified under TOLA. The Honorable Supreme Court has accordingly held that now nothing is required to be adjudicated in view of the concession. So we have direct judgment of Honorable Supreme Court on this point. And this judgment of Honorable Supreme Court has also been followed by now Honorable Gujarat High Court as well on the 17th of June 2025. We have judgments of other high courts, that is Delhi High Court as well as Karnataka High Court and few other high courts also on the similar point. So far as AY 1516 is concerned, now it is fairly settled issue that if a notice is issued on or after 1/4/2021 but before 30th June 2021, then it deserves to be dropped as it do not fall for completion during a period specified under TOLA, and it has been categorically conceded by the learned ASG before the Honorable Supreme Court. Now coming to AY 1314 and AY 1415. If notices are issued on or after 1/4/2021, then it has to be issued under a new law, and if a notice is to be issued under a new law and if the income escaping assessment is less than 50 lakhs, then the last day to issue the notice was 3 years from the end of the assessment year. So for AY 1314, 3 years would end on 31st of March 2017, and AY 1415, the 3 years would end on 31st of March 2018. So both the dates do not fall for completion within the period covered under TOLA, so those notices are barred by time. So far as AY 1314, 1415, where income escaping assessment is more than 50 lakhs. Here, if the notices are issued on or after 1/4/2021 but before 30th June, on or before 30th June 2021, in that particular case, the last date to issue the notice was 6 years. So for AY 1314, 6 year would end on 31st of March 2020, and for AY 1415, 6 year would end on 31st of March 2021. And in those circumstances, those two dates would fall for completion between 20th March 2020 to 31st of March 2021, which fall for completion during the period covered under TOLA, and that's why in those cases for AY 1415 and 1516, we have to check whether those notices are time barred or not by applying paragraph number 1112 given in the case of Rajiv Bansal. Let me give you a simple example. Let us say the notice is issued on 25th of June 2021. So the period I have now post 25th June is 26, 27, 28, 29 and 30. So I have got 5 days with me. I am keeping those 5 days aside. Let's say post the judgment of Ashish Agrawal, I was given a notice on 25th of May 2022, giving me a time of 15 days as per the direction of 15 days to file my objections. Let's take an example. Those 15 days would end on 10th of June. Now we have already seen that I had balanced days available of 5 days. So those 5 days will be added to this 10th June. So now I will have 15th June is the last date for issue of notice under 148 or passing the order under 148 AD and issue of notice under 148. The last date is now 15th June 2022. If the notice is issued on or after 15th June of 2022 under 148, then those notices would become barred by time, specifically in view of the calculations explained by an example in paragraph number 1112 in the case of Rajiv Bansal. Please mind it, the example that I have given is a different one. The dates in the example in the Rajiv Bansal is different. Purposefully I have given a different date so viewers can have now 2 set of examples available with them. The Honorable Gujarat High Court had an occasion to deal with a similar matter, and the Honorable Gujarat High Court, wide order dated 10th of June 2025, has followed those paragraphs and held that the notice is barred by time. what has happened in this case was, original notice was issued on 30th of the June 2021. 1 day's time left. So the 1 day is to be kept, the grace period of only 1 day is to be given, and that is, let's keep those 1 day aside. Thereafter, on 25th of May 2022, the notice under section 148A bracket B was issued as per the directions of Honorable Supreme Court in the case of Ashish Agrawal. 14 days time was given to file the reply, and that time expires on 5th of the June 2022. So 5th of the June, on that day the 14 days expires, 5th June 2022, and 1 day that we have kept separate, so that 1 day added, that turned out to be a 6th of June 2022. Of course, we are aware that there is a proviso given under section 149 which says that in a case where the time left out is less than 7 days, then the 7 days grace period is to be added. So the Honorable Gujarat High Court has considered those 7 days as well, and the Honorable Gujarat High Court has held that in those cases the last date would be 12th June 2022, whereas in this case the notice under section 148 has been issued somewhere on 21st of July 2022, and that's why this notice is barred by time. Friends, interesting point which is coming out of this judgment to my mind is that this judgment nowhere refers to a scenario that assessee has responded to the notice which has been issued on 21st of May 2022. It straightway calculate the notice issued on 21st of May 2022 plus 14 days period. So 21st of May 2022 plus 14 days period, which ends on 5th of the June 2022, and 1 day left out earlier, that is 6th June 2022, and then you have a minimum 7 days period. So 5th June plus 7 days, so 12th June 2022, and since the notice is issued post 12th June 2022, it is barred by time. So this judgment, I believe, is important because this would come to a rescue in a cases where the assessee might not have even responded to a notice issued under section 148A clause B post Ashish Agrawal, which has been issued in the month of May 2022. So this deals with the situation where AY 1314 and 1415 are covered, provided income escaping assessment is more than 50 lakhs. Similarly, where AY 1617 and 1718 are covered, but income escaping assessment is less than 50 lakhs, then also the last date for issue of notice would be 3 years from the end of the assessment years, and those dates are 30th March 2020 and 31st of March 2021, and even in those 2 years as well, this judgment to my mind would come to the rescue of the assessee. Now coming to a case where AY 1617 and 1718 are involved and income escaping assessment is more than 50 lakhs of rupees. We have the judgments in the case of Delhi High Court as well as in the case of Bombay High Court, where it has been held that if a notice for reopening under section 148 issued for AY 1617 and 1718 by obtaining an approval of a principal commissioner in place of principal chief commissioner, then those particular notices are considered to have been issued without taking proper and adequate sanction, and on that ground those notices have been quashed. Both these judgments have been followed by Honorable Ahmedabad ITAT as well in a judgment which is delivered in the month of April 2025. So with this discussion, all the years are covered. So for quickly summarizing, AY 1314, 1415, if income escaping assessment is less than 50 lakhs, issued on or after 1/4/2021, they are barred by time because the 3 years would end on 31st of March 2017 and 31st of March 2018, which do not fall for completion in a period covered under TOLA. If AY 1314 and 1415 are there and income escaping assessment is more than 50 lakhs, then the day game as given in para 1112 is to be applied, and it is to be checked whether the notices are time barred or not. Here the answer would depend on facts. The answer would be different for each of the particular notices. Generally, I believe that if the notices are issued in the month of June, then there are bright chances that it would become barred by time. So far as AY 1516 is concerned, in view of the concession of learned ASJ before Honorable Supreme Court, those notices deserves to be quashed. We have got series of judgments available on this point as well. And now, so far as AY 16, 17, 17, 18 is concerned, if income escaping assessment is less than 50 lakhs, the day game would be applicable, as just we spoke in a cases where income escaping assessment is more than 50 lakhs and AY 13, 14 and 14, 15 are concerned. But in a case where income is escaping assessment is more than 50 lakhs and AY involved are 16, 17 and 17, 18, then those notices would be quashed if they are issued after obtaining approval from Principal Commissioner in place of Principal Chief Commissioner of Income Tax. I hope that all those judgments would come to your rescue and probably majority of our litigations would be resolved in favor of the assessees. I believe that this judgment would be useful to you all. With this note, I take a leave of yours. We'll see you soon in the next video. Please take care of yourself.